Good morning, everyone, and welcome to our Beasley Allen webinar presentation on the next phase of the Camp Lejeune litigation. For those of you who are joining us for the first time, we want to thank you for sharing your day with us. And for our longtime viewers, we so appreciate the opportunity to help you meet your annual CLE requirements. So, as most of you know, the August deadline to file administrative claims for compensation under the Camp Lejeune Justice Act has come and gone. But there's still a lot of work to be done, an enormous amount of work to be done. And here at Beasley Allen, we've got a wonderful team of lawyers handling that next phase of this important litigation. The head of our team, Rhon, serves on the Camp Lejeune Plaintiffs Executive Committee and on the Plaintiffs Resolution Committee, where he and other committee members are working to ensure that all the impacted victims are properly compensated for their injuries. So I'm delighted to introduce three very important members of our Camp Lejeune team, Rhon Jones, Travis Chen, Wesley Merillat, and Saima Khan. Together, Rhon, Travis, Wesley, and Saima will discuss the next phase of the Camp Lejeune litigation, and they'll be taking your questions as well. So before I turn the program over to our speakers, and while we're waiting on the last of our registrants to join us, let's go over a few CLE housekeeping notes. First, today's webinar has been approved by the Alabama and Georgia State Bars for 1 hour of CLE credit. In order for you to receive full credit for attending, you've got to stay on for the duration of the program. A link to today's presentation was included in the Zoom confirmation email you should have received when you registered. But by the end of the week, you're going to receive another email with a certificate of attendance and an updated presentation and video link. You can email your completed evaluation form to webinars@beasleyallen.com. This webinar is being recorded. And for those Alabama and Georgia attorneys participating by phone, please email us your name, phone number, and state bar ID number. You can send that as well to webinars@beasleyallen.com, and that helps us ensure you receive full CLE credit. For those of you practicing in other states besides Alabama and Georgia, we're going to send you a certificate of attendance that you can present to your own state bar. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we're going to be adding a few more webinars throughout the end of 2024. So be on the lookout for those webinar announcements. Finally, if you have questions during today's webinar, I want to encourage you to use the question and answer feature, Q&A feature, that's located at the bottom of your screen. We're going to set aside time at the end of today's program to try and tackle all of the questions submitted by our viewers. So with that, I'm going to turn the program over now to Rhon and his wonderful team of Travis, Wesley, and Saima.
Hi, it's Travis. I want to apologize on behalf of Rhon. He is running a little bit late, so I'll start with the little introductions. We're all happy for y'all to join us today, and we are heavily involved with Camp Lejeune, and we are very, very excited to share with you this update, especially after the administrative claims deadline had passed back on August. And so without further ado, with the little intro that I just gave, I'll pass it over to my colleague, Ms. Saima Khan, who will cover the first portion of today's presentation.
Great, thanks, Travis. Good morning, everyone. I'm going to start the presentation just by talking a little bit about the numbers as it relates to the filed administrative claims. Our numbers come from the joint status reports. This slide is based on the August 20th, 2024 report, but just know there was one that came out yesterday. And that puts the total number of filed administrative claims at about 550,000. We know there's a review process going on to identify any duplicates, so the number will go down a little bit, but of course, going to finalize at a very high number of claims. The settlement offers through the elective option are being offered through the Department of Navy, the Department of Justice, and then a combination of the two working together. The slide breaks down how many offers have been made by all three groups. Looks like 137 by the Department of Navy, 95 by the Department of Justice, and then 113 with the two working together. Again, the slide breaks down how many claimants have accepted, rejected, not yet responded, but in summary, a total of about $33 million paid in total settlement offers and a little over 2,000 cases filed in North Carolina. So moving on to the next topic about filing cases, of course, the claimant's burden of proof and standard of proof. That can be found in section 804C of the Camp Lejeune Justice Act claims, and in general, the burden is on the plaintiff to prove that there is one or more relationship between the water at Camp Lejeune and the claimant's injury. That burden needs to be proved with evidence that is sufficient to establish a causal relationship between exposure to the water and the claimant's injury, or the evidence needs to be sufficient to conclude that a causal relationship is at least as likely as not. So that language is underlined because it's important. It means, 50% or more. Moving on to the defenses that we are seeing in the litigation, we've organized them into three categories. One is the United States contesting causation, the second contesting exposure, the third contesting damages. So starting with the first, the United States contests that the plaintiff's injuries were actually caused by the exposure to the contaminated water. They say there's other contributory factors like other
Saima,
environmental.
I'm so sorry to interrupt your presentation. It's wonderful, but our viewers are having a little trouble hearing you. I don't know if you can adjust your seat or the location of your mic, but it's a little tough to hear you. So just wanted to let you know.
Okay, hopefully this is better. Maybe. Okay. So talking about the defenses, we have them organized in three different categories. One is contesting causation, the second contesting exposure, and then the third contesting damages. So when it comes to contesting causation, the United States is contesting whether the injuries were caused by the exposure to the contaminated water. They say there's other factors like diet, lifestyle, genetics, exposure to other environmental factors that would have contributed to these illnesses. The second category, contesting exposure. So even when the plaintiff can prove that he or she was at Camp Lejeune for the relevant time period, the United States contests whether they were even exposed to the contaminated water based on where they may have been located on the base while they were there. And then the third is contesting damages. So when the plaintiff can prove that he was at Camp Lejeune for the relevant time period, exposed to the contaminated water, and also, the injuries are linked to the exposure, they're contesting the amount of damages that plaintiff may be entitled to. So that's kind of what we're seeing and what we're having to work against. So with that being said, I'm going to pass it on to Travis to talk about the Navy JAG portal.
So with the use, and so the Camp Lejeune Justice Act sets out two phases. The first phase, which we have already passed, was to file a claim with the Department of Navy's JAG office. And that was by August 10th of 2024. And so the question, in the interim between now and waiting for the Navy JAG office to file a response of either in some way accepting, rejecting, or in most cases non-response. There might be different issues that might arise and scenarios that might come across. But what's in front of you right now is what the landing page for the Navy JAG's claim management portal. From there, you can log in, and generally where you see in the top right-hand corner in my name, you will see a login page. You can log in, and from there, you will be brought to a landing page of all of the claims that you can have that have been filed, especially if you're a law firm. Now, if you're an individual, only one of these claimants will show up. But if you are a law firm, it will show up as what it is showing on the screen. And many of you may be asking, well, let's look at the status, and it's showing draft. All claims that were filed through the Navy JAG portal as a bulk filing with the Navy JAG office all show up as a draft claim. And so you may be worried about that it's showing draft and it hasn't shown in any way submitted, but per Navy JAG's guidance that they have provided leadership and published onto the Navy JAG's management portal under their frequently asked questions, they've addressed that as well. So there's nothing to worry about with regards to that. And so there are several things you can see. You can submit a request, my claims and settlements, my requests and messages, and also the frequently asked questions will be under the help button. Now, what we'll focus on is mainly submitting on the submitted request and my claims and settlement portions of the portal. Now, when you want to get to this page that we're looking at, you'll click on my claims and settlements, and that'll bring you to this page as well. And now let's say we want to go into an individual case. Before I get to that, there is certain parts that we will have to substantiate on a claim. Now, per the Camp Lejeune Justice Act and partially also by the guidance of Navy JAG, there are certain requirements. The basic requirements is proof of exposure, proof of injury, and any additional documentation. For proof of exposure, if the person was a military service member, you will have the most pertinent records that will prove exposure and time at Camp Lejeune will be through their military records. And it could range from several pages to hundreds of pages. I've seen the whole gamut of the records. Then also, if the person was a civil service civilian working on base, more than likely they might have a notification of personnel action. Essentially, it is a document that has been published by the federal government with regard to their assignments on what particular military bases and what station. Now, for civilians, civilian dependents who were either on base or in utero with their mother who was living on base, we might get creative and we will need proof of birth certificates. Sometimes those birth certificates will show that they were born at the Naval Hospital or in or around Jacksonville, North Carolina, where Camp Lejeune is located. And beyond the top three, which is what we mainly try to obtain, we can also try to get creative and try to get postcards, letters that were written around the time of exposure at Camp Lejeune, pictures at Camp Lejeune, either on the base or at different parts, marriage and divorce decrees that show if let's say a spouse was married and claims they were living at Camp Lejeune with the service member, well, we will want to know exactly when they were married to be able to substantiate that at the time the service member was stationed at Camp Lejeune, that they were married and they had a good reason to be on base living with them. And that list of proof of exposure is not all encompassing. Again, you can get very creative. Whatever can support as proof, I would recommend that you try. In terms of injury, it's very kind of straightforward. You will have to show medical records that are certified that show treatment or diagnosis prior to August 10th, 2022. And that date may seem a little arbitrary, but that is the date that has been established per the Camp Lejeune Justice Act. And in cases where it's a wrongful death, you would have to also show a proof of death through this death certificate or some other legal documentation, along with possibly a cause of death that of an injury that could relate to the toxins that were in the water at Camp Lejeune. Now, other required documentation in this case for specifically, oh, my apologies. The other required documentation would require the need of letters of administration and letters of testamentary in order for a state representative, such as an executor or administrator, to be able to bring the suit on behalf of the decedent. And in that case, the other required documentation for wrongful death cases would be the estate administration letters. Now, there has been an issue of whether or not the appointment of the estate representative had to be prior to August 10th of 2024 in order to bring it. But in responses and motions between the federal government and leadership, the federal government has in some part agreed that the estate representative appointment did not have to be effective prior to August 10th of 2024. And another issue that I see that I come across when it comes to the estates is whether or not it should be a full probate estate or a small estate, because some states allow for very small probates. But in this case, for the purposes of Camp Lejeune, it would be required that it be a full estate rather than a small estate, because based on the amount the state statute prescribes as what is the maximum estate proceeds would have to be under, that would fall under a small estate probate. Now, going on to passing on from claims substantiation, there is possibly a client or a law firm deciding somewhere down the line that they do not want the law firm to represent them any further, or the council has decided in some circumstances that they can no longer represent the client no more, either the client or the state representative. And there is a mechanism that the Department of Navy has provided to allow the update or a change to the claim representative. In this cases, if you are an attorney filing the claim, you will be your law firm or whoever you have assigned as the point person to file those claims under will be the claim representative. If you were an individual, you will be under a claim representative. And in some cases, if you are an individual who wants to sign with a law firm later on down the line to handle the litigation portion, you can also go in and submit a request, and that will be under the submit a request button that's on the homepage too. And there are certain requirements and forms that you will need to provide that the Navy JAG has provided what you will need. Now, let's say somewhere along the lines, instead of wanting to change a counsel or hire an attorney later on down the line, the claimant or the law firm or the law firm have decided to either amend or withdraw the claim. There is a mechanism for that as well, but this goes more into when you go into your claims and you select the individual claim ID. You'll see it'll show up as this, and this has been redacted, but this is one of our clients. So when you log in, you'll see an individual claim, their claim number, claim ID, their claim status, and all additional information as to who the filer is and so and such. Now, in the right-hand corner, there'll be an action button that has, you can either create a message to Navy JAG, you can view the claim itself, you can also withdraw or amend the claim. And so under the individual claim, you cannot, once you have filed the claim, you cannot on your own, let's in very simple terms, can't do it by yourself. You will have to request that the claim be amended from Navy JAG, and you'll have to state a reason as to why you need to amend the claim, because there are some circumstances where Navy JAG and their officers may be in the middle of reviewing your claim, and any changes would substantially change their review of the claim itself. And there are certain parts we do not fully support what the federal government has stated under their individual claim notes. But what they state is if you amend a claim, you have to give the Navy JAG unit 6 additional months to review the claim. But and they state that's only for what constitutes as substantial changes. And at this point, we don't know what would constitute a substantial change to the claim. But that is what Navy JAG has stated on their website. Now, if you want to withdraw a claim, you will click the withdraw button. And again, you can't unilaterally withdraw the claim yourself. You will have to request that the claim be withdrawn, and you also have to provide a reason as to why. And this is what you will show up if you choose to withdraw the claim. You will type in your reason, and you'll confirm, and then you will, maybe 10 or 20 minutes later, once it has been approved by Navy JAG, you will receive an email that states, making it official, that the claim has been withdrawn, and that no other claims can be filed. And at that point, the claim has run its course. And so with that being said, my colleague, Wesley Merillat, he will cover over what goes on after you have filed the administrative claim.
Good morning, afternoon for some of you, and welcome, and thank you, Travis. So I'll dive a little bit into these 4 likely scenarios of what happens after you file this claim. This is stopping short of some kind of global resolution. If the Navy accepts the claim and it makes an offer, your client accepts it, and that can either be an elective option offer, or it can be an administrative offer, then case over. If the Navy accepts it, makes the offer, client rejects it, if it was an elective option, then the matter just moves to full administrative review. If it was an administrative claim offer, then that 6-month period, or the 180-day period for which you have to file suit starts to, the clock starts running on that. Again, if it's, the Navy could also just deny the claim. That triggers the 180-day period to file suit. If no action is taken by the Navy, then it's our position that under the Federal Tort Claims Act, which the Camp Lejeune Justice Act refers to in this regard, that the time to file your complaint into court has not started. So that technically could run indefinitely. 2 years from now, if the Navy has never formally and finally denied the claim, your period to file suit hasn't run. A formal denial has to be under that statute, has to be in writing and sent to the claimant via certified or registered mail. So that's something just to kind of be mindful of when you're considering when, are you going to file? Do you have to file? If you haven't had a formal denial yet, you're probably going to be good. I'll talk a little bit more about this elective option. Oh, I do want to touch base on what Travis said. Again, if you amend your claim, and an example of an amendment would be your client passed away after you filed the claim. The Navy says go in and amend that because that is an additional injury claim, but that probably would be substantial, and that may restart that 6-month period. We have the elective option. We've dealt with this, have a lot of hands-on experience with it, and we've actually resolved some cases with it. So we're pretty familiar. Again, basic qualifications, you need 30+ days at Camp Lejeune, just like any other claim. You need a qualifying injury, and in this case, they created a injury schedule you can see up there. Has 2 different tiers to it. And then you need proof of your diagnosis. And that diagnosis has to be within 35 years of your client being at Camp Lejeune. It also, their injury can't have occurred within 2 years of first being there. We have seen some people who have had injuries that real short after their real short duration after their first exposure, but it has to be at least 2 years after first exposure, and within 35 years of your last exposure. So if you have that kind of client, and there's some interest in the pursuing an administrative claim, you know, you need to go into that portal. You need to substantiate the claim, you know, uploading the supporting documentation. They're very specific. It has to be certified documentation. And then the Navy will review it. If you want to try to draw attention to it, you can use that message function that Travis pointed out in the portal and just let them know you have a client that may be interested in this. When they make that offer, you're given 60 days to accept it. So again, this isn't for everybody. There are certain pros to it, and there are definitely cons to it. You know, the pros, it is a sum certain. You know what you're going to get. You're getting it over with quickly. Some of these clients, their health isn't great. You know, they're older, so they just want some finality to this. This may be an option for them. There isn't that burden of proof that is going to take place with a full administrative review. There are no lien waivers, or there are lien waivers and no offsets from Medicare, VA. So that could be, you know, significant if they've covered a lot of the care in this case. Attorney fees are reduced for the client. So by statute, this is a administrative compromise. So under the statute and the release agreement requires the attorney fees to be reduced to 20%. And again, it's a very quick turnaround. In our experience, we've received, I believe, within 2 weeks of full submission of the documents, the check has been requested from the Department of Treasury, and then that's almost been immediate payment. But again, this isn't for everybody. You know, it's a very case by case, very specific analysis you kind of have to do. You know, personally, you know, our firm doesn't believe that these amounts equate to kind of fair and adequate compensation for clients with these types of injuries. This compensation is only for one injury. So, you know, we've had clients that have bladder cancer and then they have kidney cancer. It is only going to pay for the highest tier in qualifying injury, and you're releasing them from all others. So in situations like that, an administrative review might be the better option. And again, the compensation doesn't distinguish between degrees of severity. So somebody with a kidney disease may have had their kidney removed, and someone else may have just been a minor case, so to speak. It's not going to make a distinction between those two. It's just going to pay whatever the schedule provides. So if you reject the elective option, the claim just gets put back into the pool and it will sit there and wait for a full administrative review. If you accept it, you're going to get a packet. It's going to contain a release. It's going to contain a requirement that your client sign an affirmation of truthfulness for the claim. And you just need to be mindful, again, while Medicare is waiving, there's no representations by Medicare or HMS or CMS as to what state Medicaids may do. So you do need to just do some due diligence and check on what possible government liens there may be. Okay, and moving on from the elective option. You know, you're all familiar that this act conveyed exclusive jurisdiction to the Eastern District of North Carolina. There are 4 judges there. They're coordinating this litigation. Like Saima mentioned, there's about 2,000 cases or so filed. Each judge has about 500 cases on their docket. This is not an MDL, but it is has a lot of similar aspects. It's all coordinated, of course. There is a court-appointed plaintiff counsel to leadership, which, like David mentioned, Rhon Jones is part of. There's a common benefit fund established, and there's bellwether mechanisms. The court has also appointed 2 settlement masters to kind of facilitate that kind of settlement between government and the plaintiff group. You can see on the presentation, there's a lot of different orders that the court has issued. So you just want to be real familiar with those. You know, if you're going to file a case, I'll kind of just want to cover the general framework. I'm not going to go into all these orders, but the general framework of how this is working in the litigation. The court has set up injury tracks. So it's focusing, each track is focusing on very certain injuries. So track 1 is going to have non-Hodgkin's, leukemia, bladder cancer, kidney, Parkinson's, and that's currently the focus of the bellwether cases. If you file a case, it's going to be stayed unless that case is subsequently selected for bellwether or individual track discovery. So you can file it, but there might not be any benefit to doing that. It's just there's a stay order in place. Currently, the framework for trial is coming together on these bellwethers. There is going to be a water contamination phase of the that's going to take place, where we're going to establish what kind of specific chemicals were at Camp Lejeune, what kind of concentration of those chemicals, what were they? And then what were the different exposure pathways to the people that were on base to those chemicals? After that phase, they're going to move into a general causation phase. And they're basically just going to establish a causal connection between each chemical and each track illness. Once that is done, then it's going to move on to individual trials on specific causation. Now, what Saima mentioned again, plaintiffs still have the burden. The court found this despite the language in the Camp Lejeune Act, despite that it's designed to help veterans. The court said it's not enough just to show they were on base and suffered an illness, even a presumptive illness. And even if general causation is showed linking exposure to that illness, the plaintiffs still have to meet their burden of showing that their exposure is as least likely as not the cause of their illness. So it's still going to be plaintiff's burden to show that. And again, as most of you know, there is no jury in this. The judges are going to try these cases. It appears that each judge may handle a specific track injury. So for example, one judge may handle bladder cancers, another judge is, it's suggested they'll handle leukemia, non-Hodgkin's, lymphoma, and so on. So if you want to file a case, just be mindful of the case management orders. Again, there's a stay in place, so just weigh that cost benefit. Do your due diligence and check if before you file whether your claim is elective option eligible. If it is, consult with your client as to whether that's something they want to consider or not, because If you file it at this point and you were elective option eligible, it's going to eliminate that eligibility. So you just don't want to take a source of recovery away from the client. And again, you can see the various track injury there up on the bellwether slide. There is a track 2 that's not up there. Track 2 is prostate, kidney cancer, lung cancer, liver cancer, and I think breast cancer. There are very, again, specific requirements of filing a case. These orders, the CMOs, they contain directions on doing that. So there are specific requirements relating to your pro hoc admission if you're not a member of the bar there and admitted. You know, there's a very specific requirements and orders related to pro hoc admissions. And very importantly, you just don't file a complaint. It has to be a very specific. There's orders regarding the short form complaint that you have to file. And then there are orders regarding the case management platform, which is Rubris Crosslink, and Travis is going to talk more about that. But you have to prepare your complaint, your short form complaint, in this court designated platform, and then after you prepare it, you're able then to file it. So, and again, I'll turn that over to Travis, and we can answer questions at the end, but I'll turn that over to Travis so he gets to explain more about that Rubris platform.
Thanks, Wes. And as Wes was explaining with the case management orders, which are kind of the overlapping most important orders that help steer the general overall litigation for these Camp Lejeune claims out in North Carolina. Part of one of the first few case management orders that were issued in this particular case management order 2, the 4-judge panel issued an order that anybody who was seeking any relief under the Camp Lejeune Justice Act must file a short form complaint in order to essentially uniform it across all 4 judges and all the cases that are to be filed in the future with regard to this litigation. Now, along with the use of the short form complaint, Rubris Crosslink was chosen as the litigation management database that essentially will not only generate the short form complaint, but also once the case has been filed through PACER into North Carolina, in the Eastern District of North Carolina, it will also update and populate it on the Rubris Crosslink platform. That way you don't have to go in every time to check on PACER and spend 10 cents to view just a single web page. You can see what has been filed and from time to time the updates on who has been assigned, what judge has been assigned, case number, and any outstanding requirements that the court has issued. Now, the Rubris Crosslink platform is not all encompassing. There are a lot of times that you will have to go through PACER or file something through PACER rather than fixing it through Rubris. Now, again, once you file the short form complaint, and we'll go into a little bit into the Rubris platform and the short form complaint in a little bit, but once you have generated the short form complaint, you can file it with PACER, with the court, and it'll auto-populate with the case information. And in this little right-hand corner, that's if you had filed a case, it'll show where it was filed, if it was served on the Navy JAGs, if there's an amendment or service, and any additional information that relates to the case. Now, when you will have to sign up for Rubris, and the instructions as to signing up for Rubris are contained in the case management order number 2. But once you have signed up, you will set up one for your firm. Now, before I get any further, per the court's order 47, that was the order that required all claimants to use Rubris Crosslink. Later on down the line, the court had issued an order that exempt pro se claimants from using Crosslink. So there is printable fill in the blank versions of the short form complaint that are on the Camp Lejeune litigation portal that leadership provides updates from time to time, along with their status reports and any ongoing court orders that the court issues. But for law firms, you'll be required to utilize Rubris in order to generate and continue on with managed litigation. And so this is kind of the landing page of when you create a claim in the portal, you will show essentially who's asserting it, plaintiff's name, last name, suffix, social securities, date of birth, and goes very into depth on the claimant's information. Now, if it's a wrongful death, you'll also include information regarding the state representative and any attorney information, along with any medical exposure. And going to that, this is what essentially the fill in the blank version of the short form complaint looks like, where you see Eastern District, North Carolina, short form complaint as alleged. And on page 2 of this document, it has the plaintiff's information. Part 3 has the exposure information, where it asks you the first month, last month, estimated months, whether or not they were a member of armed services or civilian. Essentially, the information is very similar to what had to be filed with the Navy JAG's claims portal, that you had to file the administrative claim. It's essentially you are copy and pasting the information that was put due to Navy JAG also onto the short form complaint as well. Now, the second page has additional information. It has this very long list. While not all encompassing, has all the presumptive injuries such as ALS, kidney cancer, non-Hodgkin's. And then on the second page, there's a section where you can add additional injuries or types of medical conditions that are not under the presumptive injuries. And while the short form complaint copy, the fill in a blank version only has 4, when you generate it in Rubris, you can add up to, I think the most I have tested is up to 20, but that is just, it takes a while to put in each individual injury, and that's kind of how far I decided to go for, but it is possible to add 20 injuries onto it. Now, talking about the state representative, that would be where you will put the information there. And so number 20 through 27, you will put in the information for the person who is either the power of attorney, a state representative, or the executor. Now, I've had a lot of attorneys reach out to me asking about what about claims on behalf of the spouse, children, from loss of consortium, mental anguish, financial support, any derivative claims. You will not file a separate action on behalf of that claimant, like the spouse or the children. It will be all encompassed under the main claimant, the service member who suffered the injury. And you will check box number 28 for derivative claim. That includes, that lets the federal government and the court know that you are seeking additional damages for loss of consortium, et cetera, et cetera. So you would not file a separate claim on behalf of a spouse, a child. It will be a claim under the main claimant, who is the service member or the person who was exposed at Camp Lejeune. Now, this doesn't mean if let's say a child who also suffered loss of mental anguish and economic harm of their parent who was exposed at Camp Lejeune, but also this child was also exposed at Camp Lejeune themselves. In that case, they would still file a separate claim on their own behalf. In that case, they would not file a derivative claim because they will also have injuries that will be claimable under the Camp Lejeune Justice Act. And the last page is essentially kind of, you have to, the other part is exhaustion is, and this goes back kind of to the 4 scenarios where either the federal government has accepted and the client has accepted the settlement and the case ends there. The federal government accepts the claim, but the client rejects the settlement offer, which in that case you will have to file a lawsuit. In scenario 3, the federal government rejects the offer and then you'll file suit. Or in what happens in the majority of situations is the federal government does not respond after 6 months, and we have it, and it is not a requirement under scenario 2, like scenario 2 and 3, where if the federal government either accepts and rejects and the client rejects, or the federal government outright rejects, you have to file within 180 days. In the scenario 4, if the federal government does not respond, it is our position that there is no statute of limitations until there is an outright rejection of the claim itself. But if you choose to, after 180 days, to file and not wait for the federal government to provide a response, you will put in the date that the administrative claim was filed, as well as the administrative claim number. And in most cases, what the administrative claim number will look like, and I can scroll back a little bit as to what a claim number will look like, but essentially it'll be a CLC number, followed, as you see under claim ID, CLC-000, and it'll have 6 other digits. So in total, it'll be CLC- and 9 digits following. That will consist of what the claim number that you will have to put in as the DON claim number under here. If the Department of Navy, and there's some certain circumstances that if you've hand filed it prior to the creation of the claims management portal, you may or may not have a claim number. In this case, you will check that the Department of Navy has not assigned a claim number, but I believe the Department of Navy is slowly but surely integrating any hand filed or bulk filings that were made prior to the portal into the actual portal itself, and should be eventually assigned a claim number as well. Now, as Wes had stated, the issue of a jury trial was struck down, but as it stands right now in the Rubris management portal, the jury trial demand is still showing as on the short form complaint, and there might be several reasons why, but as Wes stated, it was struck down by the district court, but it is currently on appeal with leadership for the right to a jury trial. But at the end of the day, this is what the short form complaint that you will need to file in order to file a lawsuit in the District of North Carolina. And with that, I'll kind of hand it over to Rhon, but I appreciate y'all joining us today. And Rhon, if you want to give any parting words for us today.
Sure. Thanks, Travis. I would like to echo that. I want to thank everyone for being on with us today. I know that your time is valuable. Everyone is busy. We are just so grateful that you chose to join us today. Our goal really is to provide you, real-time, up-to-date information that will help you with whatever work you're doing with your claims and your clients. So shortly, David Byrne, as he always does such an excellent job, he will, by the way, thank you, David, for being the moderator. This guy's just such a professional. Love him. He will have a chance for question and answer, but just a couple of thoughts before we get there. I would recommend taking a look at the latest status report that the court has, which is both the plaintiff and the government side. It's document 285. If you don't have it, just email it or email us, and we will send it to you. It's a great summary of what's going on. As Travis also mentioned, our position is now you don't need to file a complaint. You can, but we don't see the need to do so at this point unless your admin claim is expressly denied. And that is happening, very, very rarely. So we're kind of holding pat right now. We are and have entered our admin claim data into Rubris. I think that's a good idea. It's good to have that in one central location. It's helpful for the plaintiffs collectively, in my opinion. So I think that is a good idea. As you can see from what we've talked about today, there are many variables that go into taking us to wherever this ends up. Track one, you heard a good bit about today, the bench trials. The government is putting up defenses as to both general and specific causation. So I like overall where we're headed, but there are going to be some difficulties here. This is real litigation, so it's not going to be easy. But we want to be here with each of you, every step of the way to try and help. So, again, thank you for being on today. And David, you may want to moderate the Q&A. And one more thing, if we do not get to your question today live, if you email us, we will answer you and we will get you information that you need. It may take 24 hours, but we want to be very responsive on that end. So thank you again. And David, go ahead, take it away.
Absolutely. On behalf of all our viewers, I want to thank Rhon, Travis, Wesley, and Saima for a great presentation. And we've received a number of questions during your talk. And if you'll allow me, I'm going to present those to you and try to get your feedback. As Rhon mentioned, if we don't have time to catch your question today, you can submit it to any of the folks on our panel. You can also submit your question to webinars@beasleyallen.com, webinars@beasleyallen.com, and we'll make sure that your question reaches the right person for sure. So, panel, our first question comes from Jamie. Jamie asks, what are the types of arguments that the government uses for their defenses regarding damages? How do they analyze bringing down those damages?
Yeah, I'm happy to give it a shot. While we don't, know everything the government thinks, my position on this would generally be, the DOJ especially, and DON and DOJ are different, obviously, but DOJ has a consistent history of taking a relatively hard line in any sort of litigation like this. So, for instance, you may say to yourself, hey, what the heck are they doing walking back from an ATSDR? Well, they are. And David is familiar with this. He and I worked together for many years. The government is, I think, doing probably what they ought to at this point. This is a massive, sprawling piece of litigation, and they are defense-wise, they're being kind of granular. They're looking at your causation. They're looking at your general causation. They're looking at specific causation. They're looking at the time that you were deployed versus your client being on the base. So I think they're going to take the position generally that anything they can do to limit or work to defend the case, damages or otherwise, they're going to do. And so it could be any number of things regarding medical history, medical records, cost, liens, insurance. We haven't even gone there. That's probably an hour or two just on its own. But they're going to work, in my opinion, consistently to hammer any weakness, they can find in your case, in your presentation. And so I think they're going to work consistently to reduce damages across, or attempt to reduce damages, let me say, across all fronts in any way they possibly can.
Thank you, Rhon. Our next question comes from Demetrios, who asks, do we have any updates on what to do if your claim that was previously filed is not showing up on the Navy portal yet?
I can answer that one. So, and we've talked about it in our previous webinars as well. Document, especially if you hand filed it or mailed it or emailed it. Keep a paper trail of your filing. And In most cases, if it hasn't been updated on the Navy JAG portal, it might still be with the Navy JAG office itself, and it wouldn't hurt to email them to have them confirm in writing that they have received it and that is still in the process. I've had several cases that have come in where they were filed prior through paper or through email, where the attorney who referred it to us has provided us the proof that they filed it via email or certified mailing. And all it took from us was to just shoot a quick email to the Navy JAG office, and either through the FAQs that are on the portal or through the point person that they have appointed, or even through phone call, and most of the time confirm that they either have it or they don't have it. And if they don't have it, well, you still have your paper trail to prove that you had filed it.
Thanks, Travis. Our next question comes from Grace, and she presents a proof question, specifically proof of exposure. What about articles published in the base newspapers? The Globe archives are available online, and a few of our claimants were mentioned in articles or were writers for that paper. What do you guys think?
So Travis or somebody will probably add to my answer, but I think that that's an emphatic yes. Save it, hold on to it. I think we're going to see here, especially when you get back, as you go back in time, this is a massively long time that we're talking about to have a claim period. So, what we have now is in no way, shape, or form what existed back then as far as the way records were kept and things were done. So I personally would say anything that you can find in that vein, I would hold on to it and attempt to use it, because we don't know what, evidentiary standards. I mean, we know federal court rules will apply, obviously, federal rules of civil procedure, but we don't know what's going to be allowable in terms of a settlement grid or matrix or anything that there might be in that regard. So I would hold on to all those, and I think anything in that regard is fair game to be used.
Colin has a very similar question. He asks, will an affidavit from a family member substantiating a deceased person's proof of exposure suffice, such as for a civilian contractor working on base?
Right, and others may want to add here as well. Suffice, that can be tricky. But I do think that you would want to gather any information that you can. Family member, maybe you get lucky and there's a service member who was there at the same time or who was aware. So I personally would welcome statements, affidavits, anything of that nature from anyone who knew your client, the deceased, in any way. So I think that's a positive, and I would be for it. Now our team may have things to add there.
I'll just add that if it's in the case of civilian workers, you can file with the Social Security Administration for a work history transcript, and it goes back. I mean, we tested it internally. It showed my job when I was a freshman in high school, so it's going way back. So, you may find, some employment proof of employment and that documented in those records.
Thanks, Travis. I'm going to skip ahead just a bit to a question from Brad. Is there any ability to file new claims after the August 10 deadline? His office continues to be contacted by service members who say they weren't aware of the statute and the claims program.
No, unfortunately, and that is not uncommon. I've had several clients who've come to us who were not aware of the statute or were told by their VA officers saying, hold off, wait until we get a definitive diagnosis before filing one. But as the Camp Lejeune Justice Act is written from when it was passed into law on August 10th, 2022, it sets a very strict August 10th, 2024 deadline. Now that for now, presently, that is the case. No more additional new claims can be filed, but that does not. The door is always open for Congress and the president to sign into law an amended Camp Lejeune Justice Act that opens up the filing of the claims again. But as of right now, it is currently cut off.
Another question from Brad that I want to pitch to you before we wrap up. He says, just to be clear, under the statute, the 180-day period to file a lawsuit does not begin to run until a formal denial is received. Is that right?
Yeah, that is correct.
And does the DON have any duty to issue a formal denial until the claim is fully certified with proof of stay and proof of injury documentation?
No, they're under no obligation to. 2 years from now, they could still not have entered a formal denial. So it's the formal denial that's going to trigger that 180 days. If you get to the 6-month period and you don't have a denial, you are free to go ahead and file that claim on your own. But as far as the mandate and the expiration of your ability to file, it's going to expire 180 days after their formal denial.
Well, we have so many great questions, and unfortunately, we're running short on time. I'd love to stay on and answer some more questions or present some more questions to you, but I'm afraid that would hold people up. So here's what I'm going to do. Let me just go over a few final housekeeping notes. And for those of you who were kind enough to send us a question that did not get answered, would you cut and paste that into an email and send it to webinars@beasleyallen.com? Please do that, because we don't want to shortchange anybody. This is important stuff. And we want to make sure you have the latest and best information, or the best information we have available. So by all means, send those questions to webinars@beasleyallen.com. And for those of you who may have missed our earlier announcements, by the end of this week, you're going to receive an email with a certificate of attendance and an updated presentation and video link. You can email that completed evaluation form to webinars@beasleyallen.com. And for those Alabama and Georgia attorneys participating by phone, please send us your name, phone number, and state bar ID number. Again, you can send that to webinars@beasleyallen.com. That will help us ensure that you receive full credit for today's program. For those of you who practice in other states besides Alabama and Georgia, we're going to send you a certificate of attendance that you can present to your own state bar. Finally, be sure to check out the events page of our website, beasleyallen.com/events. We're going to be adding more webinars throughout the coming year and on into 2025. It's hard to believe we're winding down 2024, but we are. So thanks for joining us today. Again, send those questions to webinars@beasleyallen.com. We appreciate you supporting our Beasley Allen webinar series. Have a wonderful, wonderful day. Thank you.